My name is Narissa Ferry and I am one of the Medico-legal advisors at MDA National. As we move into another year of the COVID pandemic, it's a good opportunity for us to reflect on the challenges facing our doctor members and in particular our dedicated surgeons. As a member-owned organisation, it's really important for us to engage with you in a way that adds value to your practice. While we would prefer to see you face-to-face, another year of COVID has sadly sent us back to our screens. But I'm very pleased to be able to present a year in review on behalf of the entire professional services team. On the regulatory front, we've seen changes in the way that AHPRA conducts its investigations in an effort to deal with notifications in a more efficient manner. AHPRA will now call practitioners for a telephone discussion while a notification is in the triage or assessment stage. This is likely to be the first time you become aware of the notification. While the intention is to streamline the process for low-level matters, this step is voluntary and practitioners should remain cautious about the extent to which they provide a verbal response. We recommend you seek advice from MDA before speaking to AHPRA, as file notes of these conversations will be retained and can be relied upon as evidence in an investigation. We have also seen an increase in the number of practitioners being compelled to attend interviews under Schedule 5 of the national law. Schedule 5 interviews are requested for matters that are already under investigation, so it's not a power that AHPRA will use at the beginning of the notification process. The interviews can be lengthy and quite confronting for practitioners as they're often put on the spot and don't have an opportunity to seek legal advice before answering questions. The questions can be open-ended, which can lead practitioners to saying more than they need to and potentially making them vulnerable to further investigation. In the past, AHPRA rarely compelled interviews under Schedule 5, preferring practitioners to respond in writing, which allowed time to obtain considered legal advice and ensured that practitioners had a proper opportunity to consult their notes, reflect on their response, and to undertake any education. Unfortunately, the legislation leaves little room for practitioners to be excused from attending these interviews, so we encourage you to seek advice from MDA before participating in a Schedule 5 interview. Other changes include the establishment of triage committees to assist in expediting matters before the board. Triage committees are delegates of the medical board and convene on a more regular basis than other delegates. AHPRA also has a dedicated COVID-19 team to respond to concerns relating to the pandemic. This team deals with notifications about practitioners issuing vaccination or mask exemptions against ATAGI and other government guidelines, doctors who are critical of the public health response to the pandemic, and any other related complaints. This team tends to act quickly and seeks an explanation of any reported conduct or performance, with the goal of ensuring health practitioners are supporting the public health efforts. The national boards have published guidelines regarding the expected role of registered health practitioners, and we encourage you to visit the AHPRA website for further information. According to the annual report for the Medical Board of Australia for 2021, 5,516 notifications were lodged with AHPRA, which represented 5.7% of the profession. The most common types of complaints related to clinical care, communication and medication. No further action was taken in relation to 71% of notifications, conditions were imposed in 6% of notifications, and 0.4% had their registration suspended, cancelled or surrendered. The Medico-legal team has noticed a gradual increase in the number of queries received via email, online notifications and live chat. Unsurprisingly, given the sensitive and often complex nature of medico-legal queries, phone is still by far the most common means of contact for our members, regardless of age or stage of career. In the past 12 months, we've received around 12,000 new notifications, with around 20% of those triggering the policy. Despite the pandemic, it's largely business as usual in terms of queries, claims and investigations. If anything, COVID has just added an extra layer of complexity for everyone involved. We've seen COVID queries vary between the states and territories as public health orders and mandates have been amended and borders have gradually come down. In addition to providing personalised and tailored advice to individual members and practices, we've regularly updated our dedicated COVID webpage for ease of access. We certainly don't underestimate the additional pressure the pandemic has placed on doctors and their practice staff, both personally and professionally. Keep an eye out for our upcoming winter edition of Defence Update, which includes a pull-out feature on managing challenging patient interactions during COVID-19. Other common medico-legal themes that we are seeing are the perennial issues around privacy and confidentiality, the release of patient notes, family disputes and deceased estates, requests for medico-legal reports, employment queries, subpoenas to give evidence, and ending the doctor-patient relationship. Surgical complications are still by far the most common case types we see, followed by diagnosis, treatment, and general duty of care. An issue that comes up regularly through the management of claims and investigations for surgeons relates to patient selection. If a patient is adamant that a surgical procedure is the only way to resolve their condition, even after you have clearly advised them it's not in their best clinical interests, the inevitable outcome, if you go ahead, will be a suboptimal result. The patient may not be happy if you decline to operate, but the situation will be far worse if you go ahead with the procedure and the patient suffers a poor outcome. Our upcoming edition of Defence Update includes an excellent article on second opinions. The term second opinion has traditionally been used when a doctor seeks the opinion of a colleague to assist in a patient's management, and this may be entirely appropriate when the patient's expectations differ significantly from your treatment plan. A second opinion can also be requested by the patient, and this is anticipated in the Code of Conduct for Doctors in Australia. Second opinions can be helpful to both patients and doctors to provide reassurance or a fresh perspective on a complex or difficult clinical situation. It's important to keep the patient's best interests in mind, be clear with expectations, and communicate courteously with both patients and colleagues. If you are being asked to provide a second opinion, it's important to respect not only the patient but the initial treating doctor. Disparaging and off-the-cuff comments can lead to a complaint or claim against the initial treating doctor, even when the care provided was entirely appropriate. Advertising can be another factor in creating unreasonable patient expectations. It's important that you are familiar with the comprehensive advertising guidelines available on the AHPRA website to ensure that you're complying with the rules. Our Education Services team also recommend you keep an eye out for an educational debate about facilitating patient autonomy. This debate is an opportunity to reflect on your work, biases, values and communication, and be inspired to strengthen a patient's ability to make genuine, voluntary and informed decisions that align to what is sensible and meaningful for them. Medico-legal advisory services work closely with the team from Support in Practice, who help members to avoid claims and complaints by providing advice about practice systems and processes. One area where Support in Practice has a lot of experience and expertise is on the topic of informed consent. For there to be valid informed consent, the patient must have the legal capacity to consent, to give their consent voluntarily for the specific treatment or procedure, have enough information about their condition, the treatment options, the benefits and risks, and any alternatives available to them. This includes the opportunity to ask questions and to discuss any concerns. If you would like to have your consent forms or process reviewed, please let us know and we will refer you to the team in Support in Practice. Travel is finally back on the table, which is also a timely reminder about some of the common risks of poorly managed leave, including inadequate cover, the covering surgeon not being familiar with the patient or any peri-operative issues, a rushed or inadequate handover, reluctance to take the patient back to theatre, or a premature decision to do so, ED doctors being left to deal with post-operative complications, the covering surgeon not being aware of the treating surgeon's usual preferences, and family members trying unsuccessfully to contact the treating surgeon because they don't know that the surgeon is on leave. You can read my article on Surgeons and Holidays, What Are the Risks, for some practical tips on how you can reduce the chance of a claim or complaint. So that brings our year in review to an end. We recognise the excellent care you've provided to your patients under very difficult circumstances. We wish you all the best for the remainder of the year, and we thank you for trusting us to be your preferred medico-legal provider.